Objection, Your Honor. You already ruled that the defense attorney cannot talk about this issue. What happens here, and what does the judge do in this instance? You want to learn the answer? Come join me as I share with you something that happens all the time. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now we're at trial. The judge has previously ruled that the defense attorney is not to talk about a specific issue. So now, in the middle of questioning my witness, the defense attorney opens the door and begins asking these same exact questions that he's already been told not to talk about. Objection, Judge. The defense attorney is doing it again. He's asking questions to which you said were improper and cannot be asked. What does the judge do? The judge will likely turn to the defense attorney and say, "Counselor, you've already been warned about this. You know my ruling. You cannot ask these questions." Now, what happens next? Now the defense attorney will move on to something else. But what happens if during the course of trial he now tries to open the door again and ask these same exact questions? Well, then I have no choice but to get up and object and say, "Judge, objection, he's doing it again." What happens if he continues to do it over and over again? The judge will likely warn him again and again in front of the jury, and he will not be pleased that the defense attorney is ignoring his legal instructions to stay away from this topic. Now, I will tell you, there are probably maybe two strategies that the defense attorney might be using in order to get the judge all riled up and angered that he's now violating the judge's verbal instructions. One of the reasons is he might want to be creating an appealable issue so that he might know that he's going to lose this trial, and now he creates an issue so that now the higher court that reviews this will look at it and say, this clearly was an issue, the judge should not have ruled that way and should have allowed the defense attorney to ask these questions. That's one strategy. Another strategy that might occur, not always, but might occur, is where the attorney wants to get the judge riled up. And why would he do that? To try and generate some sympathy for himself. By playing the martyr, by saying, "Listen, Judge, I'm just doing my job. I'm trying to protect my client's interests, and I firmly believe I have a legal right to ask those questions." And the judge will say, "Great, take it up on appeal." And that's probably what he'll do, but there may be an ulterior motive where he tries to generate sympathy from the jury because now the judge is yelling at him, not once, not twice, not three times, but throughout the entire course of the trial. So, is it a smart strategy? Well, the only way to answer that question is to find out whether or not the attorney wins the case or not. So why do I share this quick tidbit of information with you? I share it with you because this does happen from time to time in cases involving accident cases, medical malpractice trials, and even wrongful death trials here in New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.